Hello, I'm Jessica Ryan Keeney. I am an attorney licensed to practice law in the state of California. I've been a family law attorney since December of 2009. What I'm going to tell you today is not legal advice. It is for educational purposes only. So today we're going to discuss if the court can make a below guideline child support order in a relocation or a move away case. And a lot of times I try to go from memory what I said and I ended up repeating myself. So I'm going to read from my script, and my son is in the office with me. You may end up seeing him or hearing him in the video. I can't do a whole lot about that. So enjoy his cameo. So anyway, in relevant part, Family Code Section 4057 reads as follows. The amount of child support established by the formula provided in Subdivision A of Section 4055 is presumed to be the correct amount of child support to be ordered. The presumption of Subdivision A is a rebuttable presumption affecting the burden of proof and may be rebutted by admissible evidence showing that application of the formula would be unjust or inappropriate in the particular case, consistent with the principles set forth in Section 4053. Because one or more of the following factors is found to be applicable by a preponderance of the evidence, and the court states in writing and on the record the information required in Subdivision A of Code Section 4056. And then we go down to subsection 5, application, and this is a reason why the court can deviate from guideline child support. Application of the formula would be unjust or inappropriate due to special circumstances in the particular case. These special circumstances include, but are not limited to, the following: cases in which the parents have different time-sharing arrangements for different children, cases in which both parents have substantial equal time sharing of the children and one parent has a much lower or higher percentage of income used for housing than the other parent, cases in which the children have special medical or other needs that could require child support that would be greater than the formula amount, cases in which the child is found to have more than two parents. So none of those sections specifically apply here. What's important to us is that subsection 5 says the special circumstances include, and they include what I just read, but are not limited to the following. So that but not limited to gives the court the ability to make below guideline orders in other circumstances that aren't necessarily listed. So what does the case law have to say about this? That's what the statute had to say. What does the case law have to say? Well, we have Wilson v. Shea, and I'm not going to read the citation. You can look at it in the comment or in the description, or you can go check it out on my website. Anyway, it's a 2001 case in which mother and father had a child together. They separated. Mother brought a parentage case against father and sought a move away order so she could move to South Carolina with the child and sought a child support order. Father sought a below guideline child support order so he could afford to visit the child. Mother opposed a below guideline child support order. After mother and father separated, mother tried interfering with the relationship between father and the child, or as the Court of Appeal called it, the systematic poisoning of the father-child relationship. One might call this parental alienation, although that's not what the court called it. So examples of the way mother interfered with the relationship, and I think this is important because it's not uncommon to see people requesting below guideline child support when they have little to no visitation and the relationship is strained. And so that's why I'm discussing this part of the case, because the court made a below guideline child support order because mother and the child moved away, even though the father-child relationship was strained. So examples of the way mother interfered with the relationship between father and child are as follows. Mother would not let father take the child to see his family. When the child was not even 5 years old, mother told the child that father's new wife was a witch. Father was not allowed to stay for the child's 5th birthday. And this was even though the child pleaded with father to stay. After that, mother told father to just leave and that she wanted nothing to do with him. She didn't want his money, and she wanted father to have nothing to do with the child. After this incident, father didn't see the child for 3 years. And then when mother filed this case and it was referred to mediation, now known as Child Custody Recommending Counseling, or CCRC, the child was petrified of seeing father. But after a few visits, the counselor noted that father was great with the child and recommended visits between father and child. So during the 3 years that father didn't see the child, he voluntarily paid $300 per month of child support. That's not something that we frequently see, that I frequently see in cases where a parent doesn't see a child. But in this case, father did voluntarily pay $300 per month in child support, and it hadn't been ordered. Despite this, mother told the child that father hadn't paid any money or anything in 3 years. Father kept paying the $300 per month in court until the court made a child support order, and that was when mother brought this action. Is when the court made the child support order. The court ordered father to pay child support of $650 per month in guideline child support. By the time the case came to trial, mother decided to relocate to South Carolina with the child, even though this meant she suffered about a $20,000 pay cut. The trial court set child support based on an earlier guideline child support calculation instead of recalculating guideline child support, and made visitation orders that involved father traveling to South Carolina to visit the child and the child traveling to California to visit father. The trial court felt it was very important to repair the relationship between father and the child, and felt it was very important that they have regular visits during the year. The child support order made by the trial court was for $150 a month to be deducted from the $650 guideline child support order, and that $150 per month was to be put in a travel fund controlled by father so that father had money to pay for visitation-related travel expenses. Essentially, the trial court made a below guideline child support order. Mother appealed this child support order. Mother had a number of contentions on appeal, but relevant to the discussion here, they essentially boiled down to, was the trial court allowed to make a downward deviation from guideline child support so that father could have money to travel to visit the child? Go read the case for the actual contentions mother made on appeal. Anyway, the Court of Appeal found that the trial court was required to recalculate guideline child support per Family Code Section 4050. Basically, use a guideline child support calculator such as DisoMaster. The court referenced Family Code Section 4056, subsection A1, which requires the court to state the amount of guideline child support that would have been ordered per the guideline formula before the court can deviate from a guideline child support order. The court held that because the trial court failed to do this, the judgment had to be reversed. The court referenced Family Code Section 4056A2, which requires that the reasons for departing from the guideline be stated on the record. Subdivision A3 requires that there also be a justification for the departure based on the best interests of the child. The court found that the father-daughter relationship was in desperate need of repair, and the only practical tool at hand was to have as much visitation as possible, even though that meant frequent transcontinental travel by the parties of limited means. The court held the legislature has declared that it is the public policy of this state to assure minor children frequent and continuing contact with both parents after the parties have separated. See Family Code Section 3020. Further, the California Supreme Court has noted that the laws give broad discretion to trial courts to modify visitation orders to minimize loss of the non-custodial parent's contact with a child in move-away cases, including allocating transportation expenses to the custodial parent. In remarriage of Burgess, again, I'm not gonna read the citation. You can go read my article. In light of these policies, it is beyond pre-adventure that the need to assure the non-custodial parent frequent and continuing contact by varying the guideline amount to provide funds for such visitation and contacts satisfies subdivisions A2 and A3 of Section 4056. And of course, these are all references to the Family Code, unless otherwise specified. The court recognized that there is case law that something contradicts the ability of the court to deviate from guideline child support to provide a travel fund for visitation. The court held there is language which in remarriage of, I'm probably going to mispronounce this, Gigliotti, might be taken for a hard and fast rule that provision of money for visitation would be insufficient to justify departing from the guideline. The language should not be taken so. The Gigliotti court limited its comment to the specific case before it. The court further held we cannot agree with any suggestion that might be extracted from Gigliotti that visitation cannot be a sufficient reason for varying from the guideline amount in move-away cases. The court noted that not only did the distance and logistics of visitation in South Carolina justify deviating from guideline child support, but there was the additional factor of mother's active interference with the father-child relationship, and that increased visitation was needed to repair the damage. The court held that the trial court's reason for deviating from guideline child support eminently satisfied the requirements of Family Code Section 4056A2 through A3, and that the trial court articulated why they were deviating from guideline child support. The court held that in this case, given the damage to the parent-child relationship and the need to repair the relationship, there was a strong showing of necessity to justify establishing a travel trust fund so that father and the child could have visitation. The court recognized that there is language in Gigliotti that some people interpret to mean that the trial court cannot deduct travel expenses from the payer parent, in this case from father, or from what the payer parent, in this case father, would pay in guideline child support. The court identified that the language came in the form of a comment after a quotation from In Remarriage of Finn, which we ourselves, that would be the court itself, quoted in footnote 8 below, and we're not quoting it here. Here is what Gigliotti had to say about it. To the extent that the court in Finn interpreted Family Code Section 4062 to permit a reduction of the guideline amount of child support, or what it denominated as a negative add-on because of travel expenses for visitation incurred by the parent paying child support, we find no such authority therein or elsewhere in the code. And that's Gigliotti. The court held that this language was dicta, which basically means it's not binding on the courts. So basically, the court in this case found that what the court said in Gigliotti about deducting some amount of child support from the guideline for travel expenses, it was okay, and what the court said in Gigliotti was not binding on the courts. The court cited Family Code Section 4062b2, which provides the court may order the following as additional child support: travel expenses for visitation. The court, citing In Remarriage of Finn, recognized that although calling it additional child support in this situation may be a bit odd, and that calling it a negative add-on might be more appropriate, the court held that guideline child support may be reduced to provide travel funds for father, who was the non-custodial parent and the parent paying child support. As for if the trial court could allow the non-custodial parent, in this case father, to have control over the travel trust fund, the court held that the question comes down to which of the two parties is more conscientious and reliable. The court recognized that the trial court was in the best position to determine this and held under the circumstances of the case before us, certainly the trial court did not abuse its discretion by allowing father to keep the money necessary to assure visitation. Ultimately, the judgment was reversed with directions to the trial court to recalculate the guideline child support amount, and the court recognized that this might result in a considerable increase in child support from the $650 a month, and that it might be appropriate to order a different amount, other than the $150 per month to be put in the travel trust fund. So relevant to the discussion here, Family Code Section 4057, I think that's supposed to be A5. I'll have to double check that. Anyway, it's Family Code Section 4057. The special circumstances provision of Family Code Section 4057 and Wilson v. Shea give the court discretion to deviate downward from guideline child support to allow the non-custodial parent to have money to visit the child in a move away or a relocation case. So there you go. This was not legal advice. This was for educational purposes only. If you have any questions, please put them in the comments below. If we do answer, it won't be legal advice, but it often makes for good discussion, also makes for good topics for future videos. Go ahead, like the video, subscribe, ding the bell so that you get notifications, and thank you for tuning in.